Second, third, or fourth, that would be better. Sidebar, I'll just try on. I don't know.
The rest of the week is from
Yes.
I Yeah, but I already moved that case. They're not gonna let me move it again. I might be able to move this. What about 2 o'clock? We do 2 o'clock on the third? Yeah, it's fine. It's fine with me. 2 o'clock on the third. But anyway, my favorite thing is just those mornings. I have cases on Mondays. I have cases whenever I continue on. I have classes. If we could do 2 o'clock. No, you're much better. 2 o'clock is fine.
Perfect.
Or 4th, either one, I can do 2 o'clock. The 3rd would be better. I came up the stairs with Joe Krosky.
That's so funny.
It doesn't work.
Remember?
Oh,
If we did
you're
it.
right, you're right.
If we did it twice.
sorry? Oh.
Especially when
Always live. In the other courtroom, we have our lunch. We'll probably do the same thing. We have to be in this courtroom. You know, maybe, I don't know, maybe I can share my partner. I don't want to put anything in writing or even get it in that lunch. I don't know. I tried. I know. Just make sure everyone's phones off. I'm just going to make announcement about cell phones. I know you folks are working.
That would have been something.
Why would we be the,
I've never had it
why
happen.
would we be the people looking for tickets to the inauguration 2025?
All right, report, please. 80. All persons have any business before the Honorable Beverly County Justice of the
You are
Norfolk
unmuted.
Superior Court and for the County of Norfolk. Go on, Nita, if your attendance, you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
22117, Commonwealth versus Karen Reed. Can I have the Commonwealth identify themselves for the record?
Good morning, Your Honor. My name is Hank Brennan. I've been appointed as a special prosecutor for the Commonwealth. Along with me is attorney Laura McLaughlin to my left
Good morning, Mr. McLaughlin.
and attorney Adam Lally.
Good morning, Mr.
morning.
Brennan. Good morning, Mr. Lally.
Good morning, Your Honor.
Good morning, Ms. McLaughlin.
For the defense?
Good morning, Your Honor. Alan Jackson on behalf of the
Good
Ministry.
morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, so we have a series of motions here. I expect we may be here a while this morning. It makes sense to me to start with the Rule 17 motions. So the first Rule 17 motion I have is the Commonwealth's motion for records from Verizon. But I do have a question for you, Mr. Brennan. Have the third-party record holders been served in all of these Commonwealth motions pursuant to Rule 17?
Thank you, Your Honor. I understand the court might have a preference that I remove from the podium. Would you like me to answer that?
It's wherever you're comfortable, as long as we can hear you.
Your Honor, I filed a series of Rule 17 motions, as I'm sure you're aware. I have not notified any of the third-party holders. I did not want to be presumptuous, seeing that I have not met the court and didn't know what the schedule would be for the Rule 17s. So I have filed these just to give everybody as much notice as possible, and my intention was to ask the court if we could set a date so that we could have these motions heard and hear the defendant's objections.
Okay. All right, so I misunderstood. I thought they were on for the Rule 17 motions today. All right, so the record holders do need to be heard. I was wondering why I did not hear from any of the parties, other than I have the defendant's objection to Mr. Reed's records. But all right, so we'll get a date, and that date should be sooner rather than later to get notice out to all the parties.
Yes, Your Honor. I'll note that we did file 2 additional Rule 17s last night. I don't know if they've been docketed.
They have been docketed. I got them, and that's why I was wondering whether the record holders had in fact been notified. So, okay, so scheduling we'll do at the end of the hearing. Then I think what we'll start with after these Rule 17s that we'll put on pause, it's paper number 48. It's the defendant's motion for relief from the order to impound sidebar conferences. And before we begin that, is there an opposition to that from the Commonwealth?
In part.
Okay. All right. Have you spoken with Mr. Yannetti about what part that is?
I've spoken to all of the attorneys numerous times. I think we're very clear what each other's position is.
Okay. All right, why don't you, all right, Mr. Yannetti, do you want to be heard by starting with the whole motion, or what?
I think we can short circuit this, Your Honor. Our suggestion, I think it's a joint suggestion to the court, is that the sidebar conferences be unsealed solely for counsel at this point. Mr. Brennan's at somewhat of a handicap because, unlike the defense team, he was not present at sidebar. He does not know what the conferences were about. And in fairness to the Commonwealth, we've agreed that it just be released to us, and then Mr. Brennan can decide if he has a further position regarding unsealing it more than that.
Okay. All right, that makes sense. Have you spoken with Ms. King about how long it will take to get these transcripts?
My co-counsel has spoken to her only...
Which co-counsel?
Mr. Jackson.
All right. What do you have to say about that? How quickly can she get them?
She works extremely expeditiously, but she has not started them, to my understanding. There's 3 reporters who probably would split the work.
Right.
And she said that she could get started as soon as there was a court order suggesting that she do so. I would imagine, given what we've gotten so far, we're talking a couple of weeks rather than a month or two. I think
Okay.
we could probably get something within a few weeks.
Okay.
2 to 3, I would guess, just based on my experience with Ms. King.
All right. Even though it's just for counsel, do you intend to have, are you asking me to unseal the sidebar conferences with the jurors?
Just for counsel, yes. I would imagine that when we get to the second stage of this, those would be in a different category from the legal rulings at sidebar unrelated to
Right.
jurors.
All right. All right. Thank you.
If I could be heard briefly.
Sure.
Thank you. Regarding the non-juror information, I'm in full agreement with the defense. I think it's prudent to, if the court would consider unimpounding the documents, I can review them. If I have
Well,
any,
you can review unimpounded documents. Counsel can review impounded documents.
then I'll begin that task. And if there's any concerns, I'll note them. If not, then I would have no concern about releasing them outside a protective order. The juror information stands in a different posture, in my perspective. I think that should remain impounded at this point. There's a pending appeal before the SJC
Yeah.
based on the request of the defense. If they are successful, would then reinvigorate the attention on those jurors. I don't see a need for juror information to be unimpounded at this point. All the other information, I don't have the same concern.
Okay. All right. Thank you. All right, the next motion. So defendant's motion for discovery of communications in the possession, custody, and control of the Commonwealth. Who's going to argue that?
I will, Your Honor. I would say at the outset that in speaking with Mr. Brennan, he had expressed a preference to be able to respond potentially in writing. So we were in agreement, subject to the court's approval, if we're going to get another date for the Rule 17 motions, to have this motion heard at that time. But I'm prepared now if the court prefers me to
No,
argue.
I'll give you the opportunity. How much time do you need to respond in writing, Mr. Brennan?
I can respond by next week.
Okay.
Really, I'm accommodating the defense. I have a very broad perspective on Rule 14 statements. Our office has made a concerted effort to provide everything that's not only discoverable under the rule, but from my perspective, a broader perspective. I want to make sure I err on the side of caution and they get every statement they're entitled to. So we're in the process of accumulating all potential statements of witnesses which they're entitled to, and I'm going to provide them to them. I've already provided a number of statements that I frankly believe are outside the Rule 14 parameters, and I'll continue to do that throughout this case.
Okay.
And so my response in writing really is to accommodate the request and then give an answer in a production of what I have. That's going to take me probably 10 days to put everything together, to adequately review it, and then to provide a package to the defense. And so I think that if I have 10 days, I might be able to accommodate the request without any need for litigation. If they decide to pursue further effort, then I can respond.
Okay. All right. So why don't we give you, we'll give you until the 27th, just after, or just before the Thanksgiving break?
Appreciate that. Thank you.
Okay. All right, does that work for you, Ms. Giannetti?
Certainly does.
All right, so let's talk about the Commonwealth's notice of scheduling, reassembly and testing of the defendant's Lexus telematics system.
May I?
Yes.
As a matter of background, as I think the court is likely aware, the Commonwealth tested information on data chips that were found in different modules that were inside the defendant's Lexus. Inevitably, at trial, the court is likely aware that there's information taken from one of the systems that was provided, and it showed information such as key cycles and different speeds. And I understand that was a exhibit at trial. There were two different search warrants by the government. One search warrant was for the car that included both a telestream and a telematics module, which is like a lunchbox with computer panels in them. And then in 2023, there was a second search warrant for the infotainment system, which is what was produced at trial. I hired an independent expert, and in the independent expert of the information, what he realized is that the information taken from the informatics manual and the information taken from the telestream manual had some irregularities. What he realized is that all of that data was unreadable. And so initially he thought that the data was not fully downloaded or compiled. He checked and he believed that gigabits were gigabytes and that there was a discrepancy. And the reason he thought this is because there was very obvious information missing from that procedure. There was information including navigation information, information regarding phones that were plugged into the radio, travel logs, things that are particularly relevant and material in this case, information that is going to be extraordinarily inculpatory or exculpatory in this case. And so after he realized his oversight on the gigabit, he filed a supplemental report. And what we learned is not only was the chips that were taken from the telematics and infotainment systems and downloaded were read with the wrong reader, so that way the information was not available. Also, in the the infotainment system, there were actually 3 boards, not 1. Only 1 was taken out. So there is a plethora of information on these chips that has not been downloaded that's relevant to this case. And so we provided notice to the defense that our intention is that we are going to test this information that we have in our control and that we have a search warrant for. And my effort was to give them notice so they could have an available expert. So my purpose really was not to ask for the defense's permission, rather it was to notice them this is what we were going to do. You can see from my motion I asked to do it within 14 days. Having recently arrived at the case, it was important for me to prioritize Rule 17 motions and new experts so that they could have adequate notice. The defense asked for today's date and wanted more time, and when I considered it, I thought that was reasonable. I think they're entitled to have an expert and consider what we are doing, even though I don't believe they have standing to prevent it. And so that's why I agreed to this date. Inevitably, we know that this information will be on these chips. And so we know there are 2 boards on the system that weren't tested, and then the other chips that were tested that came back with unreadable information with the proper computer programs, they call them programmers, we will get viable information from both of them. And so I've spoken to the defense. I know they've hired an expert. I know they've filed a motion contesting our position. I'm not going to speak for what their position is today. But I would say 2 things. One, the defense in their motion asks to have their expert be able to intervene. We're not agreeable to that. They can watch and comment and criticize as much as they'd want, but we're entitled to the download. Notably, when the first download was done, the Commonwealth deferred to the defense expert to do the download. That is not my position. I don't defer that responsibility. But it was the defense expert that overlooked the proper reader that was needed for the chips that were tested, and it was the expert that overlooked the fact that there was 3 panels in the system, not 2. And our expert was astute enough to find those oversights, and that's why we now have an independent expert that is going to do this. I know experts differ. They're not frick or frack. They all have different opinions, but we've attached all of the protocol, what we intend on doing, and the reason I brought it before the court is I wanted to expedite this matter. It's important, and it...
I thought we were going to have that hearing within 14 days when we first got the motion, and then Mr. McDermott told me that the defense was looking for more time, so we gave this. But we're far into the case is scheduled currently for January 27th. Sounds like you have a lot to do before then, but as of right now, it's still January 27th. So all of these things, the Rule 17 motions, all of these things need to be done as soon as possible. So
I understand. And if I can just add, it might help in your consideration of a later motion. The reason why this is urgent to me to have this as soon as possible is because I also have noticed and hired an accident reconstruction expert. And that accident reconstruction expert will necessarily rely upon the information that is gleaned from this testing.
How long is this testing going to take?
It's a 3-day testing. It will take within a week to read it. And the sooner we have it, the sooner we can have our reconstruction expert engage in any type of task that we want them to. But they necessarily are in a holding pattern now. And that is my sense of urgency for this to be developed and done.
Who's arguing this for the defense? Okay, I'll hear you, Mr. Jackson.
Thank you, Your Honor. I'll start by saying, in principle, we don't have an objection to the retesting of the telematics or the infotainment center, our system data. The problem that we have, our issue, sort of dovetails into what Mr. Brennan was suggesting about what was done the first time. He just suggested that his new expert, Mr. Shannon Burgess, was astute enough to find something that Maggie Gaffney didn't find. Well, to bring the court completely up to speed, when the initial testing was done, the Commonwealth's expert did not know how to do a chip-off, physically did not know how to do it, Joe Paul. He turned to Maggie Gaffney, our expert, who did know how to do it. She's a former MSP officer and extremely facile in this world of
And you
chips.
have a different expert now, you're not using her now?
Well, we may use her, but we have an additional expert who specifically works, Mr. DeSorga, specifically works in chip-offs and chip-ons. That physical procedure of moving chips on and off of boards. It's a very technical procedure. It's a very skilled procedure. He knows how to do it. He's got an extremely long resume, having done this kind of work.
I read it.
We're bringing him up to speed in order to sort of engage in some oversight and some observation. I don't have a principled objection to doing the retesting. What I have a problem with is that their new expert, Mr. Burgess, right at the beginning, fundamentally misunderstood the data set on the 3 chips, the 2-micron chips and the expansion chip that he looked at, didn't understand the difference between megabytes and megabits, gigabytes and gigabits, and that gave us pause. If he didn't understand that, which is at the foundation of reading the data, we're concerned that some of the data could be destroyed in whatever process he engages in. Like I said, we don't have a principled objection to the work that's going to be done. We simply want to make sure that nothing is destroyed in doing that work. It's not, and I would take a little issue with something Mr. Brennan said, it's not that the data set is missing information. We don't know that it's missing information. Burla has now updated software that we believe, I think both sides believe, could be beneficial in culling or teasing out that data set from those chips that didn't exist when Ms. Gaffney did her work previously. She put it on a reader, it was unreadable. It doesn't mean that the data is missing. It means that it's unreadable. As a matter of fact, one of the things that our expert would do and would suggest is that a process called a checksum be done. I'm going to use some made-up numbers, but let's say there's 5,123 bits or bytes on a particular chip. You can do a checksum and determine that there's 5,123 bits and bytes read now. That means down to the bit or the byte, nothing has been altered, nothing's been changed, and we know that we're dealing with the exact same data set. That checksum would be the first process in doing the additional reading. Then they can go back and use the additional Burla software to see if the data set could be read. After that's done, then my understanding is there would need to be a chip on. They'd need to resolder those specific chips, the 2-micron chips and the expansion chip, back onto the motherboard, install the motherboard back into the truck, and then turn the truck on. That's the process that I understand. My only request is that our expert, obviously, given his expertise and his knowledge of this information, he should be there to observe. And the only caveat to that is if he makes a determination, working with Mr. Burgess or observing Mr. Burgess's work, that what's about to happen is destructive to the data on the chips, we would ask gently, and I don't think this is much of an ask, that he be allowed to interpose his objection to moving forward, contact both counsel, both parties, and if need be, present his objections either to us to resolve it or to the court for intervention. That's all. I want the work done, but I want to make sure that the data set that is on those 3 chips or additional chips that are read is never destroyed or in peril of being destroyed. That's all.
All right. Any response, Mr. Brennan?
The defense expert would not be working with Mr. Burgess. He'd be observing Mr. Burgess. The defense expert has no active role in this testing. There is no inherent risk that Mr. Burgess is going to destroy something unnecessarily. This is potentially destructive testing, just as it was the first time. Fortunately, the information was not destroyed the first time, so we can access it again, but it's potentially destructive testing. The defense is not entitled to veto power during the process. That will delay things. It has no role or no purpose in it. And so, inevitably, Mr. Burgess is well qualified. Mr. Burgess is competent, and he is going to test these ships and provide the information to the defense. They'll get an exact copy. The idea of checksum, there's no mystery to these words. There's a protocol that's followed where they use the old software that was ineffective, and they test to make sure it's the same amount of data that's unreadable. And after they confirm that nothing has been moved or destroyed or tampered with, then they bring in the right programs, the right software, and they'll retest it properly. It'll provide the information that will be available to both us and the defense.
All right, so if I act on this motion quickly, because there isn't a basic objection to it being retested, when can they begin, Mr. Brennan?
Your Honor, I spoke to my expert this morning, and I asked him for a schedule when he could test. I told him I'd like it as soon as possible. We didn't finish the conversation. What he told me is December 2nd or 3rd. I told him that would be inadequate. That's too far out. I want it done before Thanksgiving because time is of the essence, and I think it really develops everything else that will happen in this case as far as other experts. So I need to resume my conversation with my expert, encourage him, and insist that we make some changes in schedule. So I can't give an exact date because that conversation wasn't what I was expecting, but I don't think we can tolerate waiting that long.
Okay. All right, this one I will act on very quickly. All right, so I think that just leaves us with the motion to continue. I know it's a joint motion, but I need to hear from both sides as to why I should do that. Mr. Brennan?
Can I begin?
Yes. And the request is for an April 1st date. You're not looking to go any further than that, correct?
We are not. We are not. Your Honor, the Commonwealth has been on this case for some time, and I am newer to the case. I'm not looking for a personal accommodation, but I think the idea of a motion to continue in our joint request is in the interest not only of justice, but I think inevitably, I truly believe it's going to have a more efficient and effective trial. A part of my perspective is to move as quickly as I can, and that's why I've started with the Rule 17 motions. I've also tried to retain as many experts as quickly as possible. The experts will need to do whatever testing they're going to have and conduct, and then I need to provide the reports to the defense. The defense then may have counter-experts in reciprocal discovery that I want well in advance of trial. When I first entered the case, I was committed to January 27th, and I still am. If the court decides that's more appropriate, I will be ready on January 27th. However, I realized when I was trying to move and facilitate the testing of these ships in 2 weeks, and the government, the defense wanted more time, and I appreciated that their request was reasonable. I began to understand that it is going to take a little bit more time than I wanted to have the experts notice, the reports done, and then the defense have time to manage whatever the information is. I do not want to get into a position where we're turning over expert testimony, they're retaining experts to counter that testimony, and then to reciprocate in discovery where days, weeks, are in the midst of trial. I want to avoid unfairness to the defense at all costs, but I also want to avoid any unfairness for the prosecution, and that includes reciprocal discovery. And certainly, the reciprocal discovery cannot happen until I've provided everything that I intend on using. I have tried to exercise extraordinary diligence in this case. In addition to Rule 17s, and in addition to retaining experts, we have brought on my full-time paralegal, and we are going through the entire discovery. And I know it's already been provided, but it wasn't Bates numbers, which I'm accustomed to. And we are re-indexing all the discovery and re-providing it, even though I expect most or all of it has been provided. And I'm doing that out of an abundance of caution so I can be confident that the defense has every document I have. That will resolve or prevent any delays at trial of inadvertent late disclosure or any concern or confusion about documents that have been provided. I also, with the office, have diligently moved to obtain all Rule 14 statements so that we can get the information to the defense as soon as possible. I've employed a practice when I'm retaining experts. I don't wait until we've done testing or reports. I immediately give the CVs to the defense so they can get started on investigating and looking into the experts. So nothing is held back when I receive it. If I receive any information that is discoverable or frankly not discoverable, I provide it to them. You can see in my discovery notices when I get emails from strangers with theories that I don't even agree to, that I don't know, I don't evaluate it, I give it to the defense. And so we're doing all of this to try to be as efficient as possible to avoid delays at the time of trial. And it will allow me, when I evaluate this case, which I'm still in the process of doing, of reducing the witness list substantially. And so although it does delay the case, if you allow this motion, I think it will make for a shorter, more effective, efficient trial, and I think it will be, importantly, more fair to the parties involved. And that's why I asked you to consider that continuance. I do not expect I would come before you and ask for another continuance. If something cannot get done in time with an expert of my choosing or that I would like, I appreciate I won't be able to use that expert. And so I think the joint request is something that is legitimate. I think it's well thought, and I leave it to Your Honor. Thank you.
All right. Who's going to argue this for the defendant?
I will, Your Honor. I'm not going to belabor the point. I mean, not surprisingly, in a joint motion, I agree with the argument made by Mr. Brennan. You've heard that there will be new Commonwealth experts. There are no reports yet. There have been no disclosures. No forensic testing has yet taken place. And the time frame, according to the motion, is somewhat unclear at this point. Clearly, once testing is complete, disclosures are made, we would have the right to consult with our experts and potentially employ additional experts depending on what the testing.
Have you been working on that, though, in anticipation?
We have,
Okay.
yes. Mr. Brennan has promised to index all discovery so that both sides can be satisfied that full disclosures have been made. I know he's been working diligently on that. He needs a little bit more time to take care of that. I would remind the court that during the last trial, we were still receiving reports and some discoverable material as trial was ongoing, sometimes deep into a trial. And we're really trying to avoid that this time. It's really not fair to Ms. Reed that discovery is not complete well in advance of trial so that we can assimilate and incorporate that discovery into what would now be a retrial. And our position is, Your Honor, there's simply not enough time between now and January 27th to get all of that done and properly prepare for trial. And I would just close by saying that both sides and the court have an interest in having this matter proceed to trial expeditiously. But in our view, and I would expect in the court's view, the most important consideration here is Ms. Reed's right to a fair trial. And in light of what's outstanding and what needs to be done, we believe she would not be able to receive a fair trial at the end of January. We're essentially asking for a 2-month delay, which I believe is reasonable in light of what we've already discussed. We do not anticipate any further continuance requests, just like Mr. Brennan said. So we'd ask the court to allow this motion.
All right. What do you anticipate we need to do for in-court hearings? You mentioned in your motion, in the joint motion, a Daubert hearing. How many dates are we talking about? We already need a new date now for Rule 14, for the Rule 17 motions that we have. So we need to start moving forward with all of this. Is there going to be a Daubert hearing, and who is the witness that you anticipate a Daubert hearing on? I'd like to get that on our schedule now.
We have not yet drafted the motion, but I've given it much thought. The government at trial called an expert regarding a dog bite. Forgive me, I haven't watched all of the trial.
No, that's fine. All right.
That expert, I do not believe, followed the proper methodology or had the expertise to make.
All right. Does the defense intend to call Dr. I've forgotten her name.
Dr. Russell.
Dr. Russell, do you intend to call her again?
I expect that she will be on our witness list.
All right. So why don't we set a Daubert hearing sometime in December? Does that give you enough time, Mr. Brennan?
It does, Your Honor.
Okay. So why don't we set a Daubert hearing I know you'll have to fly her in, but why don't we get a date now in December for that?
Does the court anticipate that being a different day than the date we're going to set for the Rule 17?
Rule
motion?
17, we're doing as soon as possible. We'll do before
Understood.
that date.
Understood.
So we're going to need. Maybe we can have it filed on the 25th.
So, Mr. McDermott.
May I approach Mr. Brennan for a minute?
Sure. Jim, can you pull up, Jimmy? How was, it's December 10th. I think we moved both our trials yesterday.
Would the 13th of December be available for a Dalbert hearing? It's a Friday.
Possibly. I think we just put something else on this morning that would be time consuming.
I could also do the 12th if Mr. Brennan's available, and in my co-counsel.
I was looking at the 10th, but, Jim, could you look at the 13th or the 10th?
Yeah, this is the 10th.
The 10th work for both of you? The government's available on the 10th.
So I have a, you cannot do the 10th, okay.
Your Honor, just to be completely candid, I have nothing on the 10th, but I've got to fly out on the 11th, and I've got an all-day hearing on the 11th. So, I'm sorry, I'm reversing that on the 9th. I didn't fly out on the 9th, and I've got an all-day hearing on the 9th back in California, so I can't fly that day. So,
Well,
I
court,
fly on the 10th
court ends at what time?
I'm sorry, Your Honor?
You could take, a lot of people take a red eye, right? Can you come out then?
I do every time.
You can't fly out on the 9th, the evening of the
I'll fly
9th?
out on the 9th. There's no way I can't take a flight on the 9th.
What about the 16th? It's a Monday. Is that,
We're fully booked that Monday and Tuesday.
Let's stick on the 13th. Are we still on the 13th?
Sure, if it's available. We
13th?
just, Jim, we just put Gaston on for that day. Yep, we have a full competency hearing, and we also do on Gaston. About the 12th. Let me just look at that. Did you say the 12th?
The 12th works.
I can do the 12th.
I can do the 12th.
We'll accommodate, yes.
All right, so the Darbert hearing will be December 12th.
That'd be at 9 o'clock, Your Honor?
Yes. All right.
And those motions to be filed on the 27th?
We'll get a date on that in just a minute, Jimmy. When are you available for the Rule 17 motions? How about November 26th?
I have a trial that morning
Where?
in Woburn District Court. You know, to the extent that the court would give me a protective order, I can do
Or tell them that you have a trial here, and if I need to speak to anybody, I will.
Okay, appreciate that.
Or not a trial here, but this motion hearing.
Okay.
I'd like to do it as soon as possible to get those out and get that moving.
Thank you.
So November 26th, Jim, can we do that in the morning?
Yes.
Okay.
I'm told that Mr. Jackson cannot make the 26th.
For the Rule 17 motions, do you need to be here in person?
If I could have 10 seconds.
During this moment, if I could just alert the court that there is one additional Rule 17 I'll have filed by Friday. It is similar to a number of,
File it and send notice immediately of the date.
I will.
Okay.
May I inquire, do I send notice on behalf of the Commonwealth, or does the clerk's office send?
Mr. Lally can inform you on the process, but
Thank you very
you
much.
send it right out. And
We will.
Okay.
Thank you.
Yes.
Yeah, we'll make the 26th work.
Great.
I likely will not be here, but she will
Okay.
be represented.
Are we 9 a.m.?
Why don't we do 10 a.m., Jimmy?
10 a.m. on
Get all the
26th.
record holders who want to be here.
10 a.m. on the 26th.
All right, and all the other motions are taken under advisement.
Great.
Okay, thank you very much.
Thank you.
All rise for the pledge, please.
Mr. Clerk, whenever you have a minute.
You are muted. Goodbye.
Thank you.